May I, with your lordship?
Yes.
The president of Shiv Sena, Uddhav Thackeray, had publicly and admittedly not aligned supported the BJP. In these circumstances, the satisfaction of the governor for the purpose of calling respondent 4 to be the chief minister and the head of 39 rebel MLAs of the Shiv Sena, which is endorsed by the Shiv Sena political party, is by itself ex facie unconstitutional. The Constitution prohibits recognition of rebel MLAs of a political party under the 10th schedule, and the action of the governor legitimizes what is expressly prohibited by the Constitution. The governor has sought to recognize what the Constitution prohibits. The governor is also not empowered under law to recognize who is the Shiv Sena. That is the domain of the Election Commission. Admittedly, recognition of the Shiv Sena and its leadership by Uddhav Thackeray has been endorsed by the Election Commission, and there was no dispute whatever or challenge before the appropriate authority on the 30th of June. There was no petition before the Election Commission on the 30th of June. That was filed only on the 19th of July. Uddhav Thackeray was the chief minister of the Shiv Sena. So in what capacity did the governor, Maharaj, give an audience to Eknath Shinde and administer the oath of office to him? How is that the discretion of the governor to do that? Which party was the governor, Maharaj, recognizing for the purposes of forming the government with the support of the BJP? That's, Maharaj, that's the heart of the matter, and that's nothing to do with the power of the speaker now, Maharaj. This is an independent challenge, Maharaj, on the appointment of Eknath Shinde as chief minister by the governor, and the act of the governor is subject to judicial review. In these circumstances, the governor, in his ipsit dixit, guided by his political masters in mala fide, and in the teeth of the provisions of the Constitution, granted a de facto. What it does, Malas, what paragraph 3, when paragraph 3 is deleted, the governor by his action recognizes paragraph 3. He recognizes the split. This is not a stage where the government is to be formed. This is a stage when an elected government is running. So your lordships for the first time will have to decide what are the discretionary powers of the governor in that context, and can his discretion be used to topple a government with respect to a set of people who say they are split from the Shiv Sena, when a Shiv Sena chief minister is already in place and the governor does not ask the Shiv Sena leader as to whether you are endorsing this or not? By not asking the Shiv Sena, he is recognizing a split. No, there is no discretion after an elected government is formed. The government then will fall, Mullahs, on the floor of the House. Then the question of the discretion of the governor will come in. If there's a no confidence motion, government falls, then the question will come in as to who the governor will call. But the governor cannot by his act topple a government. No, the question is not that. when Malaj, the governor was approached, when the governor was approached by BJP as well as Eknath Shinde, and governor told us to have a trust vote, Malaj. On what basis did he ask us to do that? He obviously recognized the 39, otherwise he wouldn't have asked us for a trust vote. There was no occasion to. Because they continue to be in the Shiv Sena. That's their own case. That they did not, Malaj, move away from the Shiv Sena. So if they did not move away from the Shiv Sena, which is their own case, on what basis did the governor say you have a trust vote? Unless he recognizes that the 39 members are rebels, they have split from the Shiv Sena, therefore they and BJP have a majority, therefore you go and show your majority in the House and have a trust vote. That is, well, it's logical. That's the only way to look at it. And the governor must act consistent with constitutional morality. What's the moral foundation of such an act? I've already said deletion of paragraph 3. I don't have to read. Of course, it's a principle of constitutional morality. Well, then I want to just note the page, Maharaj, in Navam Rebia at page 1145. 1144. Paragraph 210, Maharaj. Just note that. Para 210. Don't mistake the book, but just note that. I'll just read it. Last 4 lines, Maharaj, of that paragraph. Admittedly, the governor never called for a floor test, nor did he ever require the chief minister to establish his majority in the House. The governor's actions based on feuds and wrangles of a breakaway group which is not recognized under the 10th schedule cannot be constitutionally condescended.
What was the last sentence? The governor's? The last.
I'll just read it again. Admittedly, the governor never called for a floor test, nor did he ever require the chief minister to establish his majority in the House. The governor's actions based on feuds and wrangles of a breakaway group which is not recognized under the 10th schedule cannot be constitutionally condescended. It's directly on point. Because the governor, by asking me to go for a floor test, having a trust vote, has condescended to recognize a breakaway group, expressly prohibited and the governor's action struck down in Navam Rebia. So we don't have to go into the issue whether the matter should be sent back to the speaker or not. If you decide this issue, the matter is, nothing else is required to be decided. So we challenge the trust vote. We challenge the action of the governor to swear him in as chief minister. If that goes, everything else goes. Then we don't have to go into the problematic issue of sending disqualifications back to the speaker. And ultimately, Malaj, the facts are so crystal clear that they can't be the subject of yet another interpretation. They can't be, Malaj. The Constitution doesn't give him that power. The 10th schedule, he is far away, far removed from him. Para 3 has been deleted. Breakaway groups can't be recognized by that way, Malaj, every day a breakaway group will be recognized by the governor and governments will fall. I don't think, Malaj, the Republic expected this. And our Constitution, Malaj, ever envisaged a situation that can happen in our constitutional democracy. The whole integrity of the political process comes to naught.
Rameshwar says.
MLS, Nabam says the 3 areas in which the governor has discretion, beyond that, none. 371, Article 200, and Muller's forming a government at the initial stage after an election. There is no discretion with the governor. He acts otherwise on the aid and advice of the Council of Ministers. That's settled law. And of course, 356, Mullahs, sending a report to the central government. That's not something on the aid and advice, because, so 356, 200, and 371. These are the 3 areas.
Mr. Sibal, once a person incurs a disqualification
Yes.
under the 10th schedule, then the consequence under Article 193, bracket 3, is that his seat shall thereupon become vacant.
Yes.
Because 190 in terms, 193 in terms refers to 191(2).
Yes.
Which refers to the 10th schedule.
That's correct.
So the seat shall thereupon become vacant. So suppose a group of MLAs, forget this case, suppose a group of MLAs incurs a disqualification by being a split, which otherwise is not recognized by the 10th schedule.
Correct.
So the strength of the House therefore falls by the extent of the disqualification.
Absolutely.
In which case the majority required for a motion of confidence would also be altered. So suppose in a House of 200 members, 20 have become disqualified.
Right.
Then it would be 90 instead of 100 for the vote of confidence.
Correct.
So would the governor in such a case be justified in saying that, well, I still want a vote of confidence, because assuming that these people now are disqualified, I still want to test the legitimacy of the government after excluding these persons. Can he do that?
If the arithmetic is so stacked, Manas, he can, but nothing more than that.
Right.
The arithmetic is so stacked, he can.
Because the consequence is that those people have to be excluded from the House.
I agree.
The number comes down, and then he can say, well, I want...
Correct. So therefore, Manas, the arithmetic...
Minus these people who are disqualified to establish that
absolutely. No dispute on that proposition, but that the arithmetic will decide.
That the arithmetic will
decide. Here, that question doesn't arise. Yeah, we know he's made chief minister. You think by now the judges don't know he's been made chief minister? I don't understand. Well, your lordship is right, but then the arithmetic will decide. There is no discretion there. He'll call the chief minister. He says, these people are excluded. This is the arithmetic. This is what the numbers are. Prove your majority.
No, but then look at it this way for a moment. I mean, we are not at all on the facts here, but just to test a constitutional position, which is that, say we can, just for the sake of clarity, the Shiv Sena has 56.
Yes, ma'am.
Or had 56 when the government was formed.
55, right? I thought, Malas.
Oh, sorry, 55. 55. Now, disqualification notices were issued to 22 plus 16, 38.
That's right.
So, for a moment, for the argument, we proceed with your hypothesis that this is a split and therefore they are disqualified. Right? So, then the Shiv Sena is left with 17.
Yes.
If these people are to be disqualified.
Yes.
So, it comes down to then 17 plus NCP has how many? 44 or how much?
54.
53. 53 plus 17, 70.
Yeah, I just see.
And Congress has 44, right?
Yes, 44. BJP is 106. Even then, it'll be fine.
Right. So, in such a situation, would the governor be justified in saying that, look, assuming that these people have incurred a disqualification, I still call for a trust vote, because the impact of these 39, at that stage, he is not deciding the disqualification. At that stage, the governor says, well, according to me, as a constitutional head, It appears that these people they have split. I'm not deciding that they have split because that's the discretion of the speaker. Can the governor now not say in a given case that, look, these facts now stare at me. I postulate that these people have incurred a disqualification. I don't treat these as members of the House at all. But therefore, because these people stand excluded, and the strength of the ruling of the government then falls down to the extent of the extent of the split. I want a trust vote.
Well, that's right. Let me analyze that in two ways. Number one, you can't then administer an oath of office to one of those who is disqualified.
Yeah, you're right. Absolutely correct. Your line of thinking and line of argument on this is
okay. Now let's forget that.
That we'll keep aside.
We'll keep aside. Now, the power of the somebody should tell the governor that constitutionally what happens, from my little experience, the numbers, if stacked against the government, will go to the governor and say that the leader of the house has lost the confidence of the house.
Right.
Then he will analyze that and call. But governor will not do this. That's not his job. There's a sitting chief minister. It's an elected government.
You're right. At that stage, the governor is not really calling upon someone else to form government. But what he can certainly do is that, well, according to me, you have a ruling party with, say, which is supported in a coalition with, say, 60 members. Out of the 60, 40, which is a split. The governor says that, well, this is a split, and this is a split which is not recognized now by the 10th schedule. The speaker is going to take his own time to decide on the disqualification. But as the constitutional head of state, I do believe that with these 40, having, contrary to the constitution, moved away, at least as a head of the state, I require a trust vote on the floor of the Legislative Assembly. That I don't believe the governor would be wrong in calling for a trust vote.
I will say it is wrong, then I'll constitutionally provide an answer.
Why would that
The moment a governor does that, take Maharashtra. There are any number of parties apart from Shiv Sena, apart from NCP, apart from Congress. There are so many small parties. Now, those small parties at the moment supporting whoever is in power. The moment the governor does that, the buying and selling will start. In fact, the governor will be inviting, by his unilateral act of saying, prove your majority. There's no question of proving majority. He is the chief minister. Somebody else has to tell the governor that there is no majority. These are the signatures. These are the people who are with us. He doesn't have majority. If you allow that as a constitutional principle, it will be disastrous for democracy.
No, but the very fact that a disqualification notice has been issued initially to 16 and 22, this is not a case where the governor is sort of, finding facts, in the political spectrum. The governor is informed, the governor knows that, well, disqualification notices have been issued to 16 plus 22 or a group of persons.
Yes.
Which disqualification, the wrath of disqualification, the moment it attaches to a very sizable portion of the MLAs who are part of the ruling coalition, can the governor be said to be not justified in saying that, well, I'm not deciding the disqualification, but now please establish that you have a majority in the House, and I'll decide whether your majority depends on these 39 or your majority is safe irrespective of these 39.
Even otherwise, on the arithmetic, the numbers are in favor of at that time, in favor of
because, Mr. Sibal, you are also right.
Independence of
Mr. Sibal, for the present purpose, because we still have to hear them on that aspect. Yeah. So as a hypothesis, we proceed on the basis that you are right, that these 39, they had really split. That too, a split is not recognized by the 10th schedule. Therefore, they necessarily have to go out.
Right.
Asking Mr. Eknath Shinde to form the government, that's a separate issue. We'll keep that aside for a moment. We'll have to hear them on that. But as an abstract constitutional principle for the governor, what else does he do?
Let's analyze the numbers now.
Does he say that
he still has the numbers? He still has the numbers. They are only 106. There are independents, there are other parties.
No, that point is, Sibal, that is again, because you know, can we say that then the governor is, you see, a lot of times what happens is the governor may have done something which is absolutely within his power, something which may run afoul of constitutional principle. But we have to we have to separate the grain from the chaff.
Well,
Per se, when there is a disqualification notice moved to the speaker in respect of a sizable group of MLAs belonging to the ruling party, how can we say that the governor is not justified in
well,
they're going to the
because
government saying, come on now, prove your...
when does a governor, well, we'll have to go into that question then, when does a governor call for a floor test? Then we'll have to go into that question. Has ever a governor called for a floor test on his own when there is a government in power? Never. Never in the constitutional history of India. Never. And the reason is simple. There is an elected government. He has proved his confidence on the floor of the House. There may be disqualification.
You see, because the defection has two consequences. At one level, the defection results in persons who have defected by virtue of a split ceasing to be members of the House.
Yeah.
But that very defection, which operates to exclude them from the membership of the House, also affects the legitimacy of the government, legitimacy in the sense, the strength of the government on the floor of the House. So, therefore, the very same act, which is unlawful, of a group of persons forming a split and going out of the party fold, they incur the wrath of disqualification.
That stage would have arisen if the disqualification petitions had been decided. Let's assume, Malad, that your Lordship's example is right. But that stage will arise if the disqualification petitions are decided and they are out of the House.
No, but for that purpose, can the governor not say, well, I assume that they will be disqualified,
Well,
but
he
therefore
can't say.
I need I need a show of strength on the floor of the House.
But the governor has to wait on the constitutional process, the outcome of the constitutional process. Governor cannot say, I'll assume this or I'll assume that. I'm sorry. I mean, this is a proposition of constitutional law, with the greatest respect, that will ultimately encourage the kind of things that are happening today and we see all around. Please. Toppling of the government should be the priority as far as the governor is concerned.
Mr. Sibal, you are saying that constitutionally it's impermissible for the governor to take cognizance of any of those events which are all over.
Correct.
Nevertheless, he has no power to take cognizance of either the 10th schedule notices or even the earlier notices with respect to the speaker.
Correct.
Or even those representations of violation of the whip and all that has happened in the papers over.
Yes.
He cannot by himself take cognizance of anything like that at all.
Correct.
And ask the legislator or the chief minister to prove his strength in the floor of the House.
Correct. Because they are part of the Shiv Sena. They themselves say...
We are not on Shiv Sena. We are on the power of the governor.
That's right. Even then. When an elected government is running, the constitutional principle, I humbly submit, is the following. If the numbers are stacked against the elected government for whatever reason, they can go to the governor and say, these are our numbers. These are how they are stacked. Governor verifies that issue, verifies the signatures. Normally, that's a practice that used to happen, but governors now say, we don't want to enter into the political thicket. But be that as it may, that may be a possibility then for the governor to say, look, I feel that you have lost majority because these people have come to us. But governor on his own can't do that. This is no power of the governor to help in toppling an elected government. Whereas you assume governors will act constitutionally, but how many times have you struck down, actions of the governor who have acted unconstitutionally? And once that happens, then everybody else will get into the act. All those independents and all those people belonging to small parties. I don't want to say anything more. So, please don't lay down a constitutional principle that will create havoc.
But Mr. Sibal, suppose in a given case,
yes,
not in this case, the majority of the people in power, correct, we were part of the government. They, along with the other party, correct, goes to the governor and says that, sir, correct, the present government, correct, has lost the confidence We are the persons, correct? In that case, the government
Cannot.
Governor came. Why? Because governor has to set.
They are still the party, Malad. They are still in the party. It is against paragraph 3.
All right.
Because paragraph 3 doesn't recognize majority minority.
Apropos what my learned brother said, and I remember when we were much younger, there would be that parade of MLAs before the governor.
Yes,
I don't see that now. That used to happen in the 1980s.
now it's not happening.
Yes.
Because that's why, my lord, is the right question, but whereas majority is now prohibited under 3. It
No,
doesn't
but
matter.
just taking the line of, the reasoning which my learned brother put forth, could the governor not say that, well, I want you to demonstrate that you have your majority in the house. All right, I exclude 20 people who have in an 80-member house. I exclude the 20. I learn that there are disqualification petitions against 20 out of an 80-member house. Come before me or demonstrate to me that you still have 40 MLAs before you.
But we could have demonstrated and we would have won. If those 40 are, even if they are excluded.
So therefore, Mr. Sibal, the governor can, even you
No,
concede
Malad,
this,
I
you
don't agree
concede
with
it.
that proposition.
No, that the governor can certainly say that demonstrate to me that you have 40 out of 80 MLAs in an 80-member house.
It's nobody for the. It is not for the governor to say that. It's for those people in the house to go to the governor and say they have lost majority. It's not for the governor to enter into the
Fair enough.
political.
But suppose those people, therefore, obviously the opposition in the house would say, well, they have lost their 40. In which case, what does the governor do? At a primary level, the governor says, well, now I have learned from the opposition that you cease to have 40 out of 80, which you had originally, or say 45 out of 80, because 20 have now been issued disqualification notices, so that your strength comes from 45 to 25. Now, please, prima facie, demonstrate to me that you still have 40.
Let me try and answer that.
How does the governor then
let me
proceed? What
try
does
and
the governor do in a situation
Let
like
me
this?
try and answer that. Malad's governor prima facie on the arithmetic of the house must first come to the conclusion that the leader of the house has lost the confidence of the house.
Absolutely correct.
How will he decide that? If somebody goes to him. Somebody goes to him and says, this chief minister has lost the majority, lost the confidence of the house because
Now,
these are the numbers.
Two sets of people could go. Either the opposition would go, or even the defecting MLAs would go. I mean, they have.
Can't. No, they can't.
Why? They will say that, well,
We don't support this government.
Hypothetical examples ultimately when and if it comes to your lordship's bullets, because we are not dealing with that situation. We are dealing with a person who has been recognized by the governor, who happens to be part of the 39 and who was given oath of office. We are only dealing with that issue. As and when that issue and some hypothetical stage comes in, we can debate that constitutional issue. But why?
but it's not hypothetical here at all. It's a live issue here. For the reason that once the governor is in possession of facts which indicate that a very substantial.
Which is the fact that indicates that he has lost the majority of the house.
That out of 55,
Yes.
out of 55 MLAs, 38, there are disqualification notices issued by the ruling coalition
15
itself.
plus 50, 53 plus. We have them ex facie bullets. Please, that's why go into numbers? Just see the fact.
All right, let's have the
facts,
arithmetic.
bullets, yes.
Shiv Sena had 55.
I don't know, but let's just see that.
Shiv Sena is for 55.
Sena, we'll
Congress
assume
at
it's 50.
55. Congress at 44.
PDF page 62
Congress is
of convenience.
Congress kitna tha?
53.
53.
No,
Yes.
sorry, 44.
44 is Congress.
NCP is 53.
And NCP.
And Miller's, my request to your lordships, please call for the records of the governor whether he's gone through this exercise or not.
Yeah, that's the point you're making.
Well, please call for the records if that's the case.
And how much was the BJP? 10?
106.
And independents and other parties?
Yes. We would have been,
That will be about 20 odd, no?
But you will have
20.
to exclude this.
there would be 123. Miller's halfway mark is 124. 120.
So,
Yes.
so as a result of, say, the disqualification notices which are given to 39
Yes.
out of 152, the ruling coalition comes down to 113.
Well, first of all, only 34 residents had written to the governor, not 39.
Only 34.
Only 34.
Page 313.
34
Only,
dissidents
only
wrote to the
34 wrote to the governor.
governor. Right. So I'll
So
just
let's
39, if you
get the arithmetic then.
if you exclude, it comes to 120.
eighteen 99 70.
Yes.
246 is the house, half of it will be 123.
Yes.
Correct?
Yes.
23.
Then they'll become 126.
So
It becomes, because then our
4 minus.
only take out 34.
How much do they have? 164?
We've now got the from Mr. Sibal 55 SS, 44 C, 53 NCP.
That's correct.
Comes to 152.
Yes.
What minus 30 now 288 is the number.
Minus 34 went to the governor.
Minus 34.
Yes.
But there were 39 disqualifications.
No, but Malaz, what went to the governor? If the governor is to look at it, then he has to look at 34, Malaz.
Certainly. So 288 minus 34.
39 were in the majority.
So 254,
287 minus 34 will be.
288, no?
288.
288.
288 was there.
287,
One
had
passed away, Malaz.
So 288 was 287.
Why?
One passed away.
One passed
One
away.
passed
So 287.
So 287 minus 34 is 253.
Yes.
So 253 divided by 2,
2, Malaz. 127.
127.
Yes. They don't have 127.
No, but the point is then the governor will say, if you exclude the people in respect of whom there is an allegation of defection from your side,
Yeah, 127, Malaz, in this arithmetic.
how do you have 127?
I'm telling you, Malaz, 54, 44, 15 is 113 plus 14 MLAs, independent MLAs. In small parties is 14.
No, therefore, now look at,
In fact, Shiv Sena will be 21.
Mr. Sibal, look at it this way. 55 plus 44 plus 53 is 152. 152 was your strength.
Yes,
Of the basic three parties which
Yes.
form the government.
yes.
From that, instead of excluding
Plus
30
14, Malaz, there are who are supporting us. Why are you excluding?
Now,
They are independent supporting us.
fair enough. Now, 152 minus 34 also, if you take,
Yeah.
you're down to 118, right?
Yes,
Which is below the 125 mark, right? Now 127 mark, below the 127 mark. Now you say you have some independents who are supporting,
there's all in supporting us.
right? There are some independents who are supporting.
Both
There is-
sides had independent supporting
Now,
them. We had 11
one second,
supporting
One
them.
second now.
One second. We're trying to look. These examples are only to see what the governor should in a situation. We are just giving.
Well, then how? Malaz, is not just what. Did he apply his mind to this issue? Malaz, this is all very well. We are happening in a court of law. But did he apply his mind to this issue?
But Mr. Sibal, one thing which we cannot therefore discount, the governor has two responsibilities. One, the governor cannot enter into the thicket of disqualification. Two, the governor cannot do anything which seems to protect those who have incurred the wrath of disqualification. There we are with you completely. Equally, what is of concern to us is that the governor, in all these political wranglings and whatever goes on in the polity, there is a very high constitutional principle, which is that whoever is sworn in as the chief minister must ultimately have accountability to parliament and therefore to the people. Otherwise, what we'll be doing is that the defections have two consequences. The defectors have a personal consequence that they get out of the house, that their seats become vacant. But equally, we cannot gloss over the fact that the defection affects the stability of the government itself. And how does the governor, as the head of the state, ignore the consequence of...
Where is that question that arises here, Malaz? Where is that question, please? How does it arise here? How did the governor? Governor didn't look at all this, what your lordship were putting to me. Ask for the records. So, Maharaj, why go into a hypothetical situation, Maharaj? With the greatest respect, Maharaj, your lordships have so much experience. Let's not tread into areas which we are not called upon to tread upon. We are here as to how 39 or whatever 34 go to the governor, and the governor recognizes the 34, knowing that they are in the Shiv Sena. There is the leader of the Shiv Sena, they recognize is Uddhav Thackeray. He recognizes the split and administers an oath of office. How does all this enter into this, into the reckoning here?
As a principle, you are saying that the governor could not have got into it, has not got into
Yes,
it, number one.
yes, it's not, yes.
And the premise for that is that the governor cannot do it constitutionally.
That's right.
He should not.
That's all that
principle
your
you
lordship
say.
is to consider. And I can understand, Mullah, I can understand the situation. There can be another hypothetical. I'm sorry.
So once there is an existing government, according to you,
Yes.
which
yes.
this was not a
That's-
government formation for the first time.
That's correct.
Then the governor, short of a no confidence vote which is brought on the floor of the House,
Yes.
the governor must ensure that the existing position continues until somebody brings a no confidence vote.
That's the only way. Now your lordships have laid that down. No longer parading, no longer comparing signatures, all that is over. So if they think, if the BJP thought that we had lost confidence, they should have moved a motion.
That is because of Bommai, which said that it's only the floor of the house.
That's correct.
Western
So you move a no confidence. How do these issues come in at all? There's no discretion.
So
with the-
according to you, as a matter of principle, absent a motion of no confidence,
That's
the
right.
governor must continue with the existing position.
That's correct, because there's an elected government.
All right, we got it. I
Right.
understand what
Now, this is much worse, that he recognizes the split and administers the oath of office.
And thereafter, the floor test was subsequently.
Yes,
That is
On fourth,
yes, on 4th,
third or fourth.
including those 39.
But there, so far speaking for myself, can the governor, correct? Because under the 10th schedule, it is for the speaker to take a decision,
Right.
correct? Can the governor, correct, on his own, without any disqualify, the speaker can take cognizance that they are disqualified?
Your lordship is right, absolutely right, but they are still the Shiv Sena. That question will still have to be answered. What is that? What are the 39? They are still the Shiv Sena. So then he recognizes the split. That's the problem, Mullah. That's why the 10th schedule, that's why the whole paragraph, this is the issue. When 3 was eliminated, it was only for the purposes, deleted, it is only for the purposes, majority or minority, you can't destabilize an elected government. And constitutional morality was the linchpin, Mullah. So Mullah, and that's why I told your lordships, ideally the governor should have said, no further action, get your disqualification decided, then I will see. I told that to your lordships earlier.
But suppose the speaker doesn't decide.
Mullah,
But listen. Suppose disqualification questions are not decided at all. In the meantime, the governor is satisfied. Correct?
can't be.
He on the basis of the material on
He
correct.
can't, Mullah, that's not his job. It's the no confidence motion in the House. How is the government satisfaction after election doesn't arise, Mullah? I'm sorry. As a constitutional principle, it doesn't arise. Don't give that discretion to the governor. You will have toppling governments every other day. First the ED will go, then the CBI will go, then the governor will exercise discretion, and governments will be toppled. How's the discretion?
So speaker versus governor. Speaker versus governor, as I had said. So now the flip side of it is that without any chance for all that to be panned out, the speaker shows over anxiety to take up the matter and immediately disqualify all those who are intending
Well,
to.
the speaker should decide. Your lordships have now said within 3 months. This is the judgment of this court, that within 3 months, speaker must decide. Normally earlier, but latest within 3 months. Justice Narasimha's judgment was in
Meghachandra.
Meghanchal matter.
No, I was telling you about the flip side of it is, on the one hand, yes, governors over anxiety saying that, okay, you prove the majority.
Right, right.
On the other hand, we have a speaker exercising that discretion and says, now come on, you immediately show, I will disqualify all of you. So these are the two
But
constitutional
there's
authorities who
one is subject to judicial review, the other is not. Difference is one is subject to judicial review, the other is not.
all are subject to judicial review.
No, Malas. But once a new government is formed, Malas, if he calls for a trust, new government is formed, Malas, what judicial review?
True, true. Remedy is a different matter. I agree with you that
Yeah.
there is a remedy,
Yeah.
but really speaking, it's there.
And Malas,
What we need to interpret is the scope of the jurisdiction of the governor and the scope of the jurisdiction of the speaker also.
the speaker, of course, the scope of jurisdiction is clear. He has to decide the matter.
Scope and extent.
He has to decide the matter. And Malas,
Into the other.
So really, the governor keeps his hand.
second limb of it is, how does he call Eknath Shinde to administer oath of office? Yes. No, Malas, not just kindly come to pay
But I'm
para
not
to.
saying anything right now, but factually, my learned-
Please.
yes, all right. Factually, he
Fact-
made an
fact-
incorrect statement that there was no input given to the governor. There were 2 letters sent to the governor, which the governor has referred to in a letter to Mr. Uddhav Thackeray before he called for a floor test.
Correct,
So that
absolutely.
there is enough material for the
Once-
governor to
once-
decide that this government
I
was
think
weak.
my learned friends,
I have to ask the other side. What was the material before the governor on the basis of which he asked Mr. Shinde to form the government?
Mullahs, no, that's,
One,
Huh.
and particularly when he knew that this was really a breakaway faction of the state.
yes, how does he justify that? The question is, how do you administer an oath of office to Eknath Shinde?
It's all-
No, Mullahs, I can understand. Mullahs, there's another situation. There are multi-parties, Mullahs. Not just in this case, there's in several states, Mullahs, we have a multi-party system, several parties come together. And Mullahs, suddenly a no confidence is moved. Mullahs, or somebody seeks, and in the meantime, some disqualification petitions are pending. At that stage, the governor doesn't bother about the disqualification petitions. There's a no confidence. These fellows will vote. Kindly see, Mullahs, the consequences. We'll take the 39 to be validly members of the House, not disqualified. Disqualification petitions pending. Move a no confidence motion. Now, they can't move a no confidence motion because the 39 will be subject to the whip. So they know that they don't have majority. Therefore, what do? 39 go to the governor and say that now recognize me. So please appreciate, Maharaj, the way to ensure that the government falls is to move the no confidence. Why did they not move it? They could have, the 39 could have voted, they are members of the legislature. They did not move it because they knew that they are part of the Shiv Sena, subject to the whip. The government will sustain, will not fall. So the only way out was this conspiracy. And that was hatched much earlier. That's how they went to Gujarat and Assam. Having done that, they wrote that letter, which I read to your lordships, Maharaj. I've read that letter that, this present government, the party members are very unhappy with it. We have been not following the ideology of Bala Sahib. All that letter I read to your lordships, Maharaj. And then they go to the speaker. So whether it's majority, minority, it really doesn't matter, Maharaj. So how could the trust vote be called? Trust vote means that you have prima facie lost confidence. Governor knows that this government is not. Why we go into the matter, Maharaj, that the governor will presume that these people will be disqualified. Why do we even presume that? They are qualified till such time as they are disqualified. So move a no confidence. So, Maharaj, your lordships must ask the question, why they didn't do that? And Maharaj, let me put it this way. If they were so concerned, Maharaj, they should have voted against the whip. They should have voted against the whip. And if they had voted, this part we're over. Now, Maharaj, I just wanted to point out para 240. 240. The Sarkaria Commission is quoted. I just want to deal with that. Para 4.11.04 of the Sarkaria, Lordship has that. Page 101 of the Sarkaria Commission report specifically deals with the situation where there is no single party obtains absolute majority and provides the order of preference the governor should follow in the selecting of chief minister. The order of preference suggested is an alliance of parties that was formed prior to the elections. Kindly just mark the word alliance. The largest single party staking a claim to form the government with the support of others, including independents. Then a post-electoral coalition of parties with all the partners in the coalition joining the government. Kindly mark the word coalition of parties, post-electoral coalition of parties. And then a post-electoral alliance of parties with some of the parties in the alliance forming a government and the remaining parties, including independents, supporting the government from outside. No other exception is there. Now, kindly mark this, that it has to be a party supporting for the purposes of the floor test. There has to be an alliance as a matter of law. Therefore, the governor cannot exercise any discretion. He must ask what party you belong to. I'm done with this issue, Maharaj. Now, just two more issues and I'm finished, Maharaj. Number one, your lordships have not noticed that Gogavale was appointed as the whip from Assam. If your lordships agree with me as a proposition of law that the whips cannot be appointed in this fashion, ultimately the speaker, once that government is formed on the 3rd, recognizes Gogavale. Right, Manas? And then I am issued, our legislators are issued a notice for disqualification on the 8th of July. If your lordships agrees with my proposition of law that whips cannot be appointed in this fashion, then our notices should be quashed by this court.
Subsequent notices.
Your notice.
Under 2(1)(b) or 2(1)(a).
Yes. Against us, notices against us.
Correct.
Yes, 2(1)(b).
2(1)(b).
Yes.
But they are virtually non-issue, right?
No, it's not a non-issue. There's a notice of disqualification against me because they say Gogavale gave a whip.
You are right. You are right.
So, it's a live issue for us.
Legislators whip,
Correct?
not the political parties.
Yes, legislators whip. So, therefore, my request to your lordships is that notice for disqualification must be struck down by your lordships. If your lordships, of course, agree that you cannot appoint a whip from outside.
But that's the direct challenge also.
Yes, we've challenged that.
In your
That you have challenged.
538.
Yes, I've challenged that, Manas. Now, one more point, Manas. Your lordships, Manas, in September, when a whole petition was argued that the Election Commission should not proceed, your lordship said no stay. Fine, Manas, no stay. We went back. Manas, what happened was we thought, and this is my, we interpreted the order to mean that the proceedings before the commission should go on. Fine, Manas, let them go on. The problem arose that we told the commission that if you take this test of organization and representation in the legislature, you necessarily will have to include 38 or 39. And therefore, if you take that into account, your outcome, your result may be that they get the symbol. But that very matter is pending before the Supreme Court about the disqualification of these 39. So please stay your hands and let the Supreme Court decide. Now, I personally feel, Manas, that was not it was not antithetical to your lordship's order of stay. After all, the Election Commission has also to decide in accordance with law. The result was, this is again the sad part of it, the result was the commission says, I'm not going to bother about the organization. These 39 members are majority, therefore they get the symbol. In fact, your lordship's order was misused.
But we are not considering the validity of the order passed for the election.
No, I'm not asking, Malas. I'm really saying the commission said, the High Court said, Supreme Court has said no stay, therefore they have to decide.
That is to be tested in those proceedings, no?
No, that's not. But kindly see the consequences, Malas. Kindly see how we are hurt. That's why the reference, what is the scope of powers of the Election Commission in respect of determination split within the party. Malas, I'm not, your lordship's passed, Malas, rightly so, according to me, that let the commission, but the commission doesn't have to, can't disregard basic principles that you are giving symbol to a party on the strength of those 39 whose disqualifications are pending.
And that issue is pending before this.
That's pending. And I said to them, please stay your hands. They said, no, but Supreme Court has said that we have to go on. That's how the symbol is given. See the injustice caused to us. I just make the point, Mullah, and not go further. And then the last thing, Mullah, kindly read now paragraph 115 with me. And then I'm done, Mullah.
Para?
115 of the symbols order. 15 of the symbols.
15.
Sorry.
Para
I
15
small.
also. 15.
Statute compilation, Mullah, sorry.
Important.
Page 91.
It starts, 15 is there.
Page 91 it starts, Mullah. And paragraph 15
Page 103.
is at page 103. PDF 103. Yes. 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 Says Miller's when, Lordships have it, when
Yes,
the
yes.
commission is satisfied on information in its possession that there are rival sections or groups of a recognized political party, each of whom claims to be that party. Well, I'll just stop here. So the jurisdiction of the commission starts when there is a claim that there are rival groups within the party. And it must have evidence in its possession, information in its possession, and must be satisfied with the information that is in their possession. That they are rival groups. Now, your lordships have seen the correspondence, 21st June onwards. There is not a whisper of any rival group. Not a whisper. It's only the 39 sitting there.
So this just to rephrase it, according to you, there was no information in the possession of the EC
Yes.
to show that there are rival groups,
Yes,
and it
correct.
has to be satisfied.
Yes. Now, Maharaj,
No.
the petition,
Can you just rephrase your submission, Mr. Sibal, again on this point?
Maharaj, I'm saying, Maharaj, the jurisdiction of the commission will commence when the commission has it in its possession information on which it is satisfied that there are two rival factions within a political party.
Right. And in this case, what is the...
Now, let's kindly see. Therefore, in the context of this 10th schedule, Maharaj, now just that proposition. In the context of the 10th schedule, the only way you can get a symbol is when there are two rival factions within the party. It has nothing to do with the 10th schedule.
No, this has nothing to do with the 10th schedule.
Correct.
Right? So, Maharaj, there has to be a faction emerging. Take, for example, Maharaj, majority of the people in the 10th schedule are with Thackeray. Let's assume all 55 are with Thackeray. Then also para 15 Maharaj, can be invoked.
By somebody making an application.
Because 15,
didn't understand you what you're saying.
para 15 refers to the party.
That's right. So, Maharaj, the split has
Schedule refers to
correct. The
what you do on
split
the
has
floor
to
of
take.
the House.
I'm
Right.
agreeing. Maharaj, I'm saying exactly
Right.
that split has to take place within the party.
Right.
That split did not take place on 21st June or immediately thereafter. Never took place. A petition is filed on the 19th of July.
Correct. 19th of July.
Just note that, Maharaj.
19th of July.
19th of July.
19th July, absolutely.
Correct.
Right.
And on the 18th of July, it is alleged, what is submitted along with the petition is minutes of meetings. Minutes of meetings. Well, will my lord allow me to just place before your lordships. Just give it to my lord, please. Yeah, I will give you the copy. Kindly give. This is on 18th July. The matter was fixed in this court on 20th July. The petitions, all petitions were to come up for directions. So from 21st of June to the 18th of July, nothing happened. No faction, no claim for faction. Just give it to my lords, please. Now, my lords, on 18th of July, just kindly come to page 7 of this compilation.
What is this? Mr. Sibal?
Oh.
Minutes of meeting of?
Minutes of the meeting.
Of Shiv Sena.
Translation of the Pratinidhi Sabha. Page 7. Typed as page 7, my lords.
Where is the Marathi star? Just, I can read the English.
Previous to that is the Marathi, my lords.
What page?
It says on top.
It says on top, page 48.
48.
8. 3 pages before that. Or before, my lords, the English version.
46.
Now, what do you have here? Your lordships may take it, there is no summons for any meeting. No venue for any meeting. No time for any meeting. No signatures obtained at the meeting. Nothing. Just note that, my lords. No time, no place, no date is given 18 July, no summons. I suppose this is a meeting of the Pratinidhi Sabha of the Shiv Sena. So it must be known to everybody where the meeting is going to be. Summons must be sent like we sent to them. Right? What they do is they give a translation of the minutes of the Pratinidhi Sabha. And in the minutes, they show some resolutions have been passed. Minutes, as your lordship will know, is after the meeting. It can't be before the meeting. Right? It has to be after the meeting. So there is the minutes of the Pratinidhi Sabha, and there are also minutes of the Karyakarni. That your lordships will see at page 10. Again, minutes. Again, when it is held, what time is it held, where it is held. Yes, they say it happened, it is held in Bombay. I guess, Malads, someplace in Bombay. They must have known. Now, Malads, so 2 minutes are placed before the Election Commission. These 2 minutes.
Subsequent minutes also of what date? 27th?
27th of July. That's even more interesting. Well, just note the note 27 July. And then go back to the petition, Malads, that they filed. It's very interesting. These are the 2 documents that they placed, nothing more. Plus, of course, appointment of people. We're not into that. Convenience volume 2. Page, volume 2. Convenience volume 2. Yes. Kindly see page, PDF page 699. Paragraph 8. Oh, sorry. 698. Where is that? Yes. 698, Romans 626.
PDF page?
PDF page 698. This petition is filed on the 19th of July. Just mark that, Malads. This averment is made when the petition is filed on 19th July.
What is the page number, Council?
Page number.
698, Malaj. PDF 698. And just above that, Malaj, Roman 25 at 697, the last two lines of that page, if your lordship has that.
Just what is this document that you pointed out?
It says, further, a meeting of the Pratidhi Sabha was convened on 18th of July. Your lordship has that sentence? Yes. Whereby the petitioner Eknath Shinde was appointed as senior leader and Shiv Sena Mukhya Neta, main leader, minutes of the meeting of the Pratidhi Sabha. So they say minutes of the meeting are there. No meeting, no place, where it was held, when it was held, who was summoned, nothing. Right. Then come to the next para. A meeting of the Rashtriya Karyakarani was also convened, whereby the Rashtriya Karyakarani has affirmed, now please note this, has affirmed the election of the petitioner as the Shiv Sena senior leader and Shiv Sena Mukhya Neta. Now this is on 19th July, and the minutes of that are 27th July. I showed that to your lordship. This petition is filed on 19th July. He says that the petitioner was elected as the senior leader and senior Mukhya Neta. The minutes are dated 27 July. This is what they filed, Manas. So 19 July, they could not have known what would happen on 27 July. And that also minutes of meeting. These are the only two documents with the commission. That's why I read paragraph 15. These are the two documents with the commission. In respect of, to prove that there are two factions arising. And second document was submitted during the course of hearing, but be that, I don't want to go into that. I'm just only interpreting 115, 15. This is the documents in their possession, information on the basis of which Election Commission is satisfied that there are two factions within the party. So minutes of meeting. Well, that's...
Where are the minutes of meeting here in this compilation page, PDF page?
Yes, we just shown that one. Here and it's not there.
No,
that's why we...
It's not an annexure.
That's why we gave that to your lordship.
Just a symbol, but that's not an annexure to the petition. Are we right?
It's not here, Malad. That's why I gave your lordship.
No.
Where are those
What
minutes?
I'm just, let me hear my lord.
What you have read of this para 26, para 25 refers to annexure P5, which is the minutes of the meeting of the...
We haven't put it, Malad. That's minutes.
We don't have. But the petition also does it and close it is what we are trying to understand.
Yes. That was handed over, Malad. It doesn't say. That's why we gave it to your lordship.
That is of the 27th.
Yes. So now it says 27th. This petition is filed on 29th. These are... They did enclose the second one. They didn't enclose. First one they enclosed. P5 they enclosed. So, Malad, these are the two documents with the commission. Now, if you read paragraph 15, this represents two factions in the party, the minutes of meeting. That's how the Election Commission, Malad, got jurisdiction, according to them. And Malad, this is a final order. This is kindly just look at it. I can understand if the commission says lead evidence. I can understand, please prove your case. On this basis, a final order is passed, which is the subject matter of challenge in the other proceeding. That's how they got the symbol. So what does the governor do? What does the Election Commission do? And this is the evidence. And then we have to, we must ensure, we must trust that all institutional authorities function in accordance with the law. And if this kind of manipulation takes place, Malad, in the processes of institutional decision making, where we go, Malad, where we will go, I don't know.